Welcome back to another edition of Between Two Fars. I'm Warneke Miller, and I am very pleased to be joined today by David Schuman and Robert Tepfer. Dave and Bob are just, one is fresh from the battlefield as well as a veteran attorney, and then the other one is just, you know, an icon of litigation knowledge here at NASA. And we just wanted to get these two gentlemen here together today to talk to you, the attorney, the paralegal, the litigation team who has just come out of ASBCA litigation, trying to catch your breath. And now you realize you've got to file a post-hearing brief. Where do you even begin? How do you decide to boil down these years of discovery and litigation and trial into a document that's going to be NASA's last word in this case? How do you get started? Bob, Dave, what have you got to say to this attorney team?
Well, my gut reaction is, and this is very idealistic because I fully appreciate that management gives you minimum resources. Okay, back to the theory that they won the case, you're just trying to put some stuff on and carry through. But in an ideal world, and I would definitely shoot for this, it wouldn't necessarily be perfect. You'd start almost at the middle of discovery, putting together what you've got, what you're looking for, such that you can find the documents and get certain information from specific witnesses, and you go all the way through, whether or not, and then you work to the pretrial brief and you write it. That one comes after you've gone through discovery, you've done, you know, depositions, documents are there. And then what I would do, and it's just because I get scared easily, is I'd write the post-trial brief before I had the hearing to the extent I could, such that you don't end up at the end of the hearing sitting there saying, goodness, I wish I had asked that question. I wish I had put in that document, and it's too late now. So if you use that kind of as a map to how you're going to handle the case, subsequently at the end, it's already written. You're going to obviously rewrite it 50% and refine it, depending on what you get at the hearing. But you shouldn't be surprised. It shouldn't be like, hey, why don't I try this? Why don't I reference that? You ought to have it all organized such that the hearing went the way you wanted it to go, and you have those elements outlined in the brief.
Well, Dave, what if you hadn't had the time to pre-write your post-hearing brief? I know that you came off of a very intense 5-year litigation battle with constrained resources. That's an understatement. So I'm kind of guessing you didn't have your post-hearing brief written as you went in. In your case, how did you get started? How did you figure out what should go into this post-hearing brief?
I'm going to add to Bob's great advice by going a little bit higher, 10-mile up view. So looking down from the top, first of all, if you're fortunate to have co-counsel, a good discussion to have leading up to the hearing and post-hearing is who's going to be responsible for what in the brief. This is not a small detail, and you're going to be page limited, and you need to figure out in your team who's going to cover what topics and how they're going to be merged and coordinated. That's point one. Point two, in terms of writing the post-hearing brief, it's important to keep in mind that it doesn't have to be perfect. It doesn't have to be 100% comprehensive. And the reason for that is the burden is on the claimant to establish entitlement. And it's when you're having periods of stress and self-doubt, good to keep that in mind. They really need to put on all the evidence to establish entitlement. You need to shoot holes in it. It's not a criminal trial, beyond a reasonable doubt, but you need to make enough sufficiently strong points to put holes in the argument that the claimant's entitled to payment. So not every topic has to be covered. You won't be able to cover every topic. You'll have topics that you covered in the hearing. We had probably the flip side of this problem. We had a lot of really, really good evidence. We couldn't include it all. because of the page limit. The judge did ask the parties at the close of the hearing, and each judge is different, what the page limit should be. And keeping in mind the burden, I thought, well, hey, shorter the better for us, right? Make it tougher on the other side. So, you know, they wanted 100 pages. I said 25. The judge said, and it just, again, back to the nature of the individual judges, you may have opportunity for a post-hearing brief and a reply brief following the other side's opening brief, or you may not. In the Stennis litigation that was concurrent with ours at exactly the same time, the judge had consecutive filings. In other words, each side filed an opening brief, each side filed an opposition, each side filed a reply. For better or worse, our judge said, we're going to do it consecutively, such that the other side gets the opening brief, the agency gets the reply brief, and the other side gets the final brief, and that's it. And so, like you said at the beginning, Warnke, you know, that's it. We had one shot. Everything had to be in there. Quite stressful. I told our folks, and this is perhaps my third point, to start on the post-hearing brief early. I wanted, in fact, even though we were going second, to finish as much of that as possible ahead of time, because I didn't want to get distracted by the other side's arguments. I wanted to make sure we knew which important things we wanted to put in there. So we actually, even though our brief wasn't due until 60 days following the hearing, because, 60 days following the appellant's brief, we started on it right away. And we actually finished it probably a couple hours before the appellant's brief came in, at least the first draft. You know, finished is an optimistic term with respect to a brief. My management said he never finished a brief, he just ran out of time. So, you know, I remember back in college, the professor said, all good writing is rewriting. And boy, is that true. You write your first draft, you rewrite it as much as possible until you run out of time. And hopefully it's sufficient.
Dave, you talked about due to page limitation, which I think almost every attorney is going to run up against in one way or the other, you had to decide what to cut from your brief. Do you have like 1 or 2 or 3 bullet points on how you decide what to cut? Because that's a very difficult determination. Yeah,
it is painful, like you cannot imagine, especially if you're lucky to have good evidence. We had a file of incriminating documents, communications between the prime contractor and a subcontractor. You know, could have taken up 15 pages in the brief. It wound up taking up a much shorter space because we needed that space for other arguments. Now, the one outlet that we did have is you will most likely get an opportunity to file a proposed findings of fact as well. And much of the material that you could put in your brief, you can put in the proposed findings of fact. That is, if your judge allows 2 separate practices.
That's a terrific practice point. That is exactly the type of practice tip that we need, because if you've got somebody sitting here struggling with what's in, what's out, it's nice to know that, hey, maybe there's this other document that you can drop some of your argument. How about things like citations that are dropped down to footnotes, arguments that maybe you can't fully devote 2 or 3 pages to? What's your thought on sticking it to a footnote with some citations to the record? Do you have any other tips like that?
That's exactly right. Explicit example. And say you've got lucky to have 15 incriminating documents between the prime and the sub. Rather than go through each one in the brief, you say, the record is replete with incriminating documents between the prime and the sub. See proposed findings of fact, paragraphs 16 through 47. That way it's in there, and you know, the judge can look at it if she wants to. I still think you want to put the most important things in the brief, you know, just to be safe. But your outlet valve, if you're allowed, is the findings of fact. Now, Stennis had a slightly different experience. I read the Stennis post-hearing brief, and they've got factual findings interspersed in the brief, and that may be because they didn't have opportunity for separate findings of fact. And on this subject, one thing you want to watch out for, and we wound up doing this in our proposed findings of fact. The first section of the proposed findings of fact is objections to the other side's proposed findings of fact, because sneaky, they put in their proposed findings of fact, 5 pages of legal argument, not appropriate, right? In fact, I talked to Paul, should we file a separate motion to strike just on that, recognizing we don't have any other pleadings, right? This is it. So we wound up just making that a separate section, but think of the findings of fact if you get one, and you should argue for that as an outlet valve for extended material that's helpful, that doesn't have room in the brief.
Terrific. These are some really wonderful nuggets that can help the attorney team to focus how they are going to tackle the post-hearing brief segment of ASBCA litigation. Bob, Dave, thank you so much for your time and your insight on all of this. We really appreciate it, and we look forward to seeing y'all on the next Between Two FARs.